Previously on the American Justice Podcast.
I, Marcial Contreras, swear under penalties of perjury that the information in this affidavit is true and correct. This Exhibit 149. I have never seen this sword in my life, and I do not remember Brandon Woodruff owning it. I never saw this sword, much less gave it to him. This inscription on the sword says "Made in China," and all swords and daggers at medieval times came from Spain and never had this kind of inscription. This sword was not ever sold at medieval times, and I did not give it to Brandon Woodruff. The dagger I gave him was for training horses, and was much, much smaller than this sword.
There is an epidemic in America's criminal justice system: the prosecution and conviction of innocent people for crimes they did not commit. Welcome to American Justice. The American Justice Podcast Army works to free men and women wronged by the criminal justice system. It's not only about the innocent who have been imprisoned, but also the victims of the crimes as well. No one deserves justice more than them. And now, here's your host, Scott Pogensey.
Welcome back, AJ Army. I'm so happy to have you with me this week as we start to wind down the first season of the American Justice Podcast. We'll cover the trial of the state of Texas versus Brandon Dale Woodruff for the next couple of weeks. Then we'll give you all of the updates on the status of the case now. So many people ask me, what is the status of Brandon's case? How many appeals does he have left? Etc., etc. We'll answer all of those questions just a few weeks from now. And then, the last episode of this season will basically just be a wrap-up and kind of summarizing the whole season into one reflective episode. I'll also let loose in that episode and give you all of my opinions that I just know you've all been dying to hear. Let's talk about the actual trial, the 13 days that would change Brandon's life forever. I think I've said the phrase, "we'll talk about that when we get to the trial," like a dozen times or more over the last few weeks. The reason for that is that there is so much of this story that needs to be explained in the context of how the jury heard it. For example, we're going to talk about the suspicious activities surrounding certain people's phone records, but it really wouldn't make sense to talk about them individually in certain episodes because you really need to understand how each one ties into another's. It's things like that. So in these few episodes, we'll talk all about Charla's phone records, the shit kicker's phone records, etc., and how they all tie in together to make one big suspicious story. Now, I think I told you over the last few weeks that the number of episodes covering the trial would be 2. Just 2. Oh, how foolish I was. Just to give you a small glimpse behind the scenes here at the American Justice Podcast, the way it usually works is that C. Derek Miller, my head writer, he writes out the skeleton of the episode, and then I come back in behind him and fill out all the rest of the body. So by the time we present it to you, our adoring audience, you're seeing a polished and well-oiled machine at work. At least we hope so. The script that C. Derek delivers to me is usually around 6 or 8 pages. And then, by the time I add all of my background knowledge to it, the script for each episode usually ends up being around 10 to 11 pages. That usually translates into about 45 to 55 minutes of finished podcast, depending on how many sound files there are to play. Well, this episode, covering just the first half of the trial, was delivered to me at 10 pages. And by the time I finished writing, it was 18 pages long. That would translate into almost a 2-hour podcast. I don't like to run the lengths of the podcast that much differently because a lot of people listen on the way to work and they just have a finite amount of time to listen. So if they don't finish it, then they have to work all day in suspense. And that, boys and girls, is not fair to them. Okay. But seriously, I don't want to make two 2-hour podcasts to cover the trial. So we're going to go ahead and cover the trial in 4 episodes. I promise you it'll all be very interesting and you will not get bored. If you do, feel free to leave a voicemail at 972-942-0444 and tell me what a blowhard I am. All right, just one more thing I want to cover before we get started. I want to address something that a lot of people have commented to me about. Some people have speculated that Brandon might have been convicted because he had court-appointed attorneys. I can tell you that the answer to this is yes and no. Absolutely 100% Brandon was convicted because he relied on the court system to provide his defense. However, this is in no way indicative of the quality of the attorneys. Hunt County is not big enough to have a dedicated public defender's office. So what they do is the court just appoints one of the defense attorneys from around town, and it's supposed to be completely random. Now, sure, there are qualifications that someone must go through to be on the list. For example, not all attorneys are capital murder qualified. You have to go through some hoops and be on the capital murder list. And Brandon ended up getting appointed Jerry Spencer Davis. By every story I've heard about Jerry, he was a force to be reckoned with in the courtroom. Prosecutors feared him, and other defense attorneys wanted to be him. However, with that said, let's talk about a few circumstances surrounding Brandon's trial in particular. First, Jerry had been experiencing some pretty severe personal problems for the couple of years leading up to trial. His best friend had just recently died, his mom had just passed away as well, and he had some pretty severe and debilitating back surgeries. And he had some other things going on, but from what I've been able to gather, Jerry just wasn't in his prime. He was getting older, and he actually ended up retiring after this trial. I have reached out to Jerry to ask for comment about this trial, but he refused to talk to me. I have a feeling that it haunts him just as much as it does everyone else. However, even though Katherine Ferguson had to step in and pretty much take over the entire trial after it was apparent that Jerry wasn't up to the task, she did a fantastic job with the resources that she was afforded. And this brings me to my last point. What most people don't understand is that when someone has a court-appointed attorney, the judge must approve literally every single dollar that the defense spends. I remember one pretrial hearing where Jerry Spencer Davis asked the judge to bring in a certain investigator on the case, and he was going to charge $50 an hour. Now, I don't know about you, but for a qualified investigator, $50 an hour sounds pretty cheap to me. But Judge Beacom was having none of it. He yelled, "You can get a private eye all over this town for $40 an hour. Go find one of them." The difference was that Jerry wanted to bring in his investigator, the one that works for him on the for-hire cases, the one that he knows and trusts. But over $10 an hour, Judge Beacom just once again put the defense behind the 8-ball. Now that might lead the naturally inquisitive listener to wonder, well, how much of what the state spends has to be approved by the judge? Your answer, ladies and gentlemen, would be 0. That's right. The state has unlimited resources at their disposal. I'll just give you the contrast in Brandon's case and you can draw your own conclusions. On August 15, 2007, Kelly Aiken filed a motion with the court to list all of her expert witnesses. She had 38 people listed. In addition to that, she also listed, quote, any other member of law enforcement that the prosecution calls. Now, the defense, on the other hand, was allowed 3. John Miner, the phone expert, Dr. Joy Carter, the forensic pathologist, and the $40 an hour private investigator. It's only fair to say that, of course, the state does have the burden of proof, so their job is theoretically much harder. But if someone is going to try and prove their innocence when the state does such a shitty job investigating the case, they're going to need some more expert witnesses. But just listen to that number again. 38 for the state, 3 for the defense. Not unfair at all, right? So the problem with having a court-appointed attorney is not the quality of the attorney themselves, but the fact that the judge can, and in most cases does, cripple your case from the very get-go. Okay, with all of that said, we're going to cover the trial this way. We're going to take it day by day. There was a total of 13 days of trial, including jury selection and the verdict. Some days are more exciting than others, and some days will go by quicker than the rest. So let's get started. Day 1. State of Texas versus Brandon Dale Woodruff, Court Reporter, Volume 40. Day 1 starts with jury selection. As with any jury trial in the country, the beginning of the process is something called voir dire. According to the Webster's Dictionary, voir dire is defined this way. In the United States, voir dire is the process by which prospective jurors are questioned about their backgrounds and potential biases before being chosen to sit on a jury. Voir dire is the process by which attorneys select, or perhaps more appropriately reject, certain jurors to hear a case. Boy, they sure hit the nail on the head in this case, didn't they? Take particular notice of the phrase background and potential biases before being chosen to sit on a jury. Here's how Philip Crawford Jr. described this process in his book, Railroaded, the homophobic prosecution of Brandon Woodruff for his parents' murders.
Philip Crawford Jr. wrote about the potential jury pool in his book Railroaded. The jury pool was comprised largely of Christian evangelicals, and the hostility against homosexuality was open and unapologetic. One individual said, "I wouldn't have a high opinion of gay people, and I would pray for them." Another said, "I just have a less opinion of them," which possibly would make him more likely to think they're not truthful. Sure, the chosen ones all gratuitously represented that a defendant's homosexuality would not weigh into their decision on guilt or innocence. But would it be okay to impanel 8 avowed white supremacists or Nazi sympathizers in a criminal trial involving a black or Jewish defendant? And yet 8 Texans who, by their own admission, viewed homosexuals as morally inferior to heterosexuals were allowed onto the jury panel to judge a gay boy.
I really wish I had the wordsmith skills Mr. Crawford does. But I guess that's why he writes books for a living and I fix broken arms on kids. Now, the trial begins with the standard jury selection. As we talked about, it's trying to put your personal beliefs aside to come up with a verdict. Can 99% of humanity honestly do this? What about now in today's social media age where people are so hell-bent on expressing their beliefs behind a veil of technology? Regardless, they're all supposed to tell the truth. But don't worry, the jury would tell the truth about their feelings and beliefs with extreme prejudice. Remember, the Hunt County DA's office has been recused at this point, so special prosecutors from the Attorney General's office, Adrian McFarland and Ralph Guerrero, introduced themselves to the jury. In turn, they introduced the defense team of Jerry Spencer Davis and Katherine Ferguson. McFarland expands to the potential jury that the Hunt County District Attorney's Office is not prosecuting this case due to a conflict of interest, but refuses to go into details. Yeah, AMAC. I'd avoid that explanation like the damn plague if I were you. We all know from experiencing the information given in the previous episodes of this season that a burden of proof is never really obtained in this trial, but she insists to the jury that one will arrive eventually. Good luck with that. McFarland adds that the intent to commit murder is a lot like purposely slapping a mosquito. Really? Is it that easy? Living in North Texas, we all slap at least 10 a day. I'm almost frightened to know how easily that could translate into the ability to commit murder at the explanation of this prosecution team. So what's next? A lesson about coloring between the lines and maybe a nap? I hate the way that people are talked down to in court. It's an insult to their intelligence. Then again, some of the population who were squeezed into the jury selection were obviously idiots. I mean, statistically. Just saying. After Ms. McFarland explained to the jury that the state would not be seeking the death penalty in this capital murder trial, several of the jurors were vocally upset that they wouldn't be the ones determining whether or not Brandon received the death penalty.
I was like this gentleman down here. I understand what you're saying, but I don't see why, if he was found guilty within a reasonable doubt, why he wouldn't get the death penalty. I don't.
Were they truly that anxious to kill someone? Were they just dying to dish out death to the potentially gay porn star they've heard so much about on the news and in the papers over the previous 3 years?
I'm gonna say, if you find him, if he's guilty, if he's truly guilty, I don't know why they couldn't give him the death penalty. Well, if it comes down to it, I could take an oath that says he won't get fried,
Hunt County needs a better way for its population to blow off steam. An adult-sized jungle gym or maybe a better gun range? It was almost as though some of them were playing rock, paper, scissors to see who would personally get to inject the needle. Many of the jurors shared this sickening philosophy.
I agree. If we can't decide the death penalty, I can't take the oath.
Many of them even expressed out loud that he was already considered guilty for being in the courtroom or for being arrested in the first place. Suddenly, several jurors speak out stating they wouldn't be able to rule fairly due to what they'd experienced in the media since the year 2005. Unfortunately, for the young, helpless defendant, their minds were already made up. If Ranger Sergeant Jeffrey Collins believed Brandon Woodruff killed his own parents, then he was automatically guilty. I do want to take one quick moment to praise one single juror, though. The lady, who shall remain anonymous, stated that she had issues with the way that Hunt County Sheriff's Office investigates things and couldn't possibly agree with any guilt. Thank you, dear lady, for paying attention. I know your name from reading the court records, and if I had the courage to track you down, I'd send you a fruit basket for your honesty. Maybe a Bed Bath & Beyond gift card. Who knows? But thank you again for standing up and recognizing what you believe to be the case. The prosecution side of things finished with their introduction and questioning of the potential jurors, and now the defense takes over. It's the same exact pathway, but from a completely different point of view. Miss Ferguson opens herself up to criticism by inquiring if anyone has a personal problem with her. After all, it's a small population, and you never know when someone has represented someone else's baby mama or whatever. Lots of ill will potentially floating around in that situation for sure. By reading some of these jurors' responses, it's easy for me to now see why attorneys' fees are so damn high. It has nothing to do with the attorney's intelligence or education. It's because a large chunk of modern society, even back in 2009, is incredibly dumb. My hat goes off to the attorneys for never running down the row of potential jurors and slapping them across their smug faces. At this point in the interview process, Katherine Ferguson asks the Hunt County $1 million question. How does homosexuality personally sway your decision? She instructs that anyone who has a conflict of interest raise their hands. Simultaneously, the majority of the box raises their hands. It actually says that in the trial transcript. A majority of jurors raise their hands. Now, did they really have an issue with this, or were they just trying to get their $40 and head home? The ones who said it wouldn't sway their opinion added that they wouldn't have a very high opinion of a homosexual, but they'd pray for them. Hunt County apparently didn't have a Chick-fil-A in 2009, so where in the hell were these jurors going to eat lunch every day? Then she asks if anyone has any close friends or family who are gay. Most raise their hands. It doesn't surprise me, as I believe probably almost every family has a gay member, even in Hunt County. After all, I don't believe that God picks and chooses where he creates gay people. It's not like he says, oops, can't put any gays in Hunt County. They'll never work out there. Nope, they're everywhere. And then after that, the only question is how comfortable they are in telling people and expressing themselves. Someone once told me that it seemed like there sure are a lot more gay people now. And I told him, no, there's the same amount. The only difference is now they're more comfortable admitting it.
At first I was afraid, I was petrified. Kept thinking I could never live without you by my side. And I spent so many nights just thinking how you did me wrong, but I grew strong. Yeah, I learned how to get along, and so you're back.
Maybe things have changed for the better in Hunt County since 2009. Maybe they haven't. But one thing is for sure, there's just as many now as there ever have been. Next, Miss Ferguson asks if anyone has a problem with people who are involved with pornography. We haven't really talked yet about the adult films that Brandon has starred in, but don't worry, we'll touch on that in this episode. No pun intended. After Miss Ferguson disappoints all of the private pervs in the room by stating she was not talking about child pornography, most raise their hand and count the seconds until they can go home and watch the above-mentioned pornography. 90-something people sitting in a jury box in 2009 in the budding days of the internet. Statistically, most of them had choice videos saved on their home computers in hidden folders, for sure. Then she asked them if they thought police officers always tell the truth. Hands popped up so fast that they almost separated from the wrists holding them to their body. This was as equally ignorant of an answer in 2009 as it would be in 2020, people. Brandon Woodruff was doomed. 12 people out of 97 drew the short straw and agreed to rule in the best of their ability, or in a way that would be pleasing to their own God when he wasn't looking over their shoulder during the quiet internet porn time. Remember, statistics, it's not speculation if it's statistically true, right? But I want to stress exactly what Mr. Crawford said in his book earlier. Would it have been truly fair to let a group of Ku Klux Klan members sit on a jury of a black defendant? I mean, anyone can say, sure, I can set my prejudices aside and come up with a verdict only based on the facts. But can they? Really? Is human nature in such a way that that is even possible? So that brings up the subject that I promised we'd talk about, and that is the possibility of a change of venue. I can't even tell you how many people ask me, man, Scott, they should have changed the venue and taken it out of Greenville. Initially, I would agree with that sentiment. In fact, I had that same question when I sat down with Katherine Ferguson to interview her for the upcoming documentary. Here's how she answered it. Was there ever discussion or even a possibility, I guess, of a change of venue to like Dallas or a more or less conservative?
Jerry and I had discussed a change of venue, and we talked about it with Brandon, and the fear that we had was that we would end up either in Rains County, which is a smaller, more rural community even than Greenville, or that we would end up in Plano, which is every bit as conservative, and I don't think there's been a not guilty in a capital murder case in Plano, at least at that time. Plano's very much a law and order environment, so it was kind of, okay, are we going, to use a cliche, are we going out of the frying pan and into the fire if we do this? Plus, the Woodruff family was known in the community here, and there were people who knew of Brandon, who knew him as this kind of nice, goofy kid who was really good with his animals and was into theater things. And so it cuts both ways. You can go to a panel of strangers that may be every bit as conservative as your pool locally, but then you also lose the whatever advantage or benefit that you get of having people who know of the family in general. So we discussed that, and we talked about it with Brandon, and it was ultimately Brandon's decision not to change venue.
So it's not possible to say we want to go to Dallas or we want to go to even Tarrant County. There's somewhere bigger, like they would assign, or how does that work?
When you get a change of venue, you don't get to pick where you go. You file a request for a change of venue, and the administrative judge assigns your case to another court. And we had no control over where it went, so we had no idea where we would end up. We knew we would end up in the DFW Metroplex area, but that could encompass McKinney, Plano, Rains County, Emory, Rockwall, which was almost as bad since it was Rockwall Heath, that area, Royse City Heath. So, I mean, we had no control. We couldn't say, we want to go to Dallas County. Please assign us to Dallas County. That doesn't happen. You request a change of venue, the court makes a decision whether or not to grant it, and then if it's granted, you're assigned randomly to another location. And you just have to hope you get a good one.
Well, there you have it. The change of venue would have been a roll of the dice for sure. And this is only if the judge even grants the motion. You can't very well stand up in front of a judge and say, look, Judge, we need a change of venue because all of the people that live in this county are a bunch of bigots. You'd be laughed right out of the court on the quick. So they would have had to have argued some other reason, and the judge may or may not have agreed with it. But even if he did, just as Katherine said, there's a real good chance that you would end up in another county just as, or even possibly more, conservative than good old Greenville. All right, so the jury is picked, and we head into day 2 of the trial. Day 2. State of Texas versus Brandon Dale Woodruff. Court Reporter Volume 41. First things first, Brandon has to actually plead in the case. So he stands up in front of his friends, his family, enemies, and peers to plead not guilty to the charge of capital murder. He says something that I personally found pretty profound. From my experience from watching trials, at this point when the judge asks, "How do you plead?" most people just simply say, "Not guilty." But Brandon went a step further and said, "I'm not guilty." Maybe just one of those subliminal body language things that Susan Constantine was talking about, but I found this rather interesting. Okay, first up, we have the opening statement by Ralph Guerrero. The prosecution paints a picture of the Woodruffs being murdered while peacefully watching television in each other's arms. No defense wounds except for Norma's gunshot through her hand. They were shot point blank and obviously trusted whoever was standing in their faces. I can't go into details, but I actually hired a crime scene reconstructionist, and no surprise, he actually disagrees with this. He says that Dennis was actually standing when he was shot, and Norma was actually standing when she was shot as well. Again, I can't go into details, but let's just say that Ralph Guerrero doesn't know what he's talking about here. He's making assumptions and presenting them to the jury as if they were fact. According to witnesses, Brandon was the last one to see them alive. This same witnesses claimed that he hated their new home because he thought it was beneath him. The prosecutors explained who Robert Martinez is and that he expected Brandon back in Denton at 6 p.m. on Sunday night. Robert said that Brandon got lost and didn't get there until 11 p.m. Ralph Guerrero promised the jury that they would meet Charla and that she was home in Arkansas at the time and tried to call, but no one answered. The family is frantic, so they phone a friend to investigate. That friend discovered the Woodruffs dead. The prosecution actually goes on to claim that Brandon's story changed repeatedly and that they would be able to prove his guilt without a shadow of a doubt using toll and cell phone records. I mean, after all, Randall Lunds, the borderline senile neighbor from Heath who couldn't remember Dennis or Norma's name, saw Brandon at home at a very specific time. The prosecution claims that Brandon wanted Norma's new-ish truck and that it was one of the reasons that he shot and killed them. The Lees lost their art/gun and Brandon had access to it. The prosecution alleged that Brandon's dagger/knife/sword was missing from the dorm room in which he kept it in 2005, but recovered it in the barn of the Heath house in 2008. A single drop of blood belonging to Dennis Woodruff was meticulously hidden behind a decorative skull on the hilt. They claimed that Brandon Woodruff definitely killed his parents. Pretty much everything we've gone over so far in the season, the only difference being that they were making some promises that they would never be able to follow through on. So after the prosecution finishes their opening statement, the defense tells the judge that they are going to reserve their opening statement for when the prosecution rests its case. It's an option the defense has, and sometimes attorneys choose to exercise it, and sometimes they don't. Okay, let's call some witnesses. This is where the real circus begins. Linda Matthews takes the stand. Remember, Linda is Brandon's aunt and Norma's sister. She talks about financial woes of the family and the motivations of the move from Heath to Royse City. She tells the story we all know up to this point from listening to earlier episodes in the podcast. She tells the jury that she told Todd Williams to break into the house and that he found the Woodruffs dead. She was shocked that Brandon had Norma's truck. Again, with the goddamn truck. This is just one more thing that the prosecution tries to snowball past the jury. I always tell people that the prosecution took what I call the shotgun approach when it came to establishing a motive. As you'll see throughout this trial, they never really settled on one motive. It was all things like, okay, well, Brandon was failing out of school and did not want to tell his parents, so he shot and killed him. Oh, you don't believe that? Okay, well, did you know that Brandon was gay and didn't want to tell his parents? So he had to shoot them at that point, right? Yes, the prosecution actually presented this theory to the jury, even though they knew just as well as anyone else that Brandon had already told at least his dad, and his dad was very cool about it. Whether or not his mom knew is a little more up in the air, but there is at least one person that confirms that she knew as well. Okay, so you don't believe that Brandon killed his parents because he didn't want to tell his parents about his budding sexuality? No problem. We have some more motives for you. Oh yeah, did we tell you that he really wanted his mom's truck? Yep, had to kill her for it. Then, of course, multiple witnesses come forward and testify that no, Brandon drove his mom's truck all the time. Oh, okay, so you don't believe that? Okay, no problem. Did we tell you that Brandon was starring in some gay porn and didn't want to tell his parents? Yep, had to kill him. I mean, it was just ridiculous. Usually, in murder trials, the prosecution will come up with one plausible theory and run with it until the cows come home. Then, either the jury buys it or they don't. But this prosecution team? Nope. They had no real plausible theory, so they ran with this shotgun approach. All right. Ultimately, Linda tells the jury that she encouraged Charla to take possession of Norma's truck after Brandon's incarceration. And I can just imagine that she jumped, within the best of her abilities, for joy. Yes, the same truck that Brandon was, quote, forbidden to drive. In 2008, 3 years after the murder investigation began, Linda and Charla inventoried the barn, and the dagger/knife/murder weapon/sword was discovered. I've talked to a couple different family members that say Charla never went there to help at the Heath house. In fact, even one time when they had over a dozen helpers from eQuest, she didn't even show up then. Now, all of a sudden, Charla volunteers to come over and lend a helping hand to once and for all finally get this barn cleaned out. And then they find the murder weapon. I mean, surely I'm not the only one that finds this suspicious that the first time that Charla comes over to actually help with the cleaning out of the barn, they find the sword? Well, I can tell you that most definitely I am not. This sentiment has been expressed to me by several people. All right, so something interesting also happens during Linda's testimony. Jerry Spencer Davis ends up asking a question to Linda about Charla's psychiatric background. And let me tell you, the fireworks explode. The prosecution, of course, objects to the defense's mentioning of Charla's psychiatric history because they think that it has no relevance to the case. Really? It's eventually discussed without the jury present so it doesn't tarnish Charla's reputation when it comes time for her to take the stand. It was also mentioned that Charla had talked to her principal in those records about someone sexually abusing her. A suspect is never named, but if it was one of the murder victims, aka her parents, it could have easily have been a motive for murder. This was never investigated further. Go freaking figure. Why am I not surprised? Okay, so now Janie Simpson, formerly with the Hunt County Sheriff's Office, was called to the stand. She was the Criminal Investigations Lieutenant in 2005 and was now a bailiff. She testifies that once the bodies were discovered and a search warrant was obtained, she entered the residence with several deputies. She and Deputy Brandon Bobbitt began collecting, logging, and labeling potential evidence. A gun, a .38 caliber, was found in the master bedroom closet. The group worked until 1:30 a.m., left a deputy to guard the house, and returned the next day. Someone on site, later discovered to be Deputy Brandon Bobbitt, at the instruction of Ranger Jeffrey Collins, had made a video recording in complete darkness, bumping and bumbling everything in sight. Soon after, Lieutenant Simpson was contacted by Norma Etherington, Mike Etherington's mother, not long after the bodies were discovered, but kept no records and had no recollection of anything discussed. Norma Etherington stated that she had information about the crime. How convenient. Okay, Lieutenant Simpson, you're excused. Then, Investigator Tommy Grandfield was called to the stand. He was the one responsible for obtaining the search warrant for the home. He claimed that there were several items of value still present in the home, including that .38 revolver. Nothing of value, such as jewelry or electronics, was taken. I never understood how the police could determine that. How do they know that a big pile of $10,000 in cash wasn't sitting on the table? How do they know that the Woodruffs were not drug dealers and had oodles and oodles of cocaine just sitting around? I mean, they hadn't done any investigation yet. This was still the processing of the initial crime scene. I still don't understand that to this day. So Investigator Grandfield then testified that he covered the victim's hands in brown paper bags and secured them with tape to capture any potential evidence. He received information from Charla to revisit her parents' home with a very specific request to search a very specific location for the murder weapon. This was a few days after they had released the crime scene. However, upon that further search, nothing was found. Nice try, Charla. Nice try. He was also the one who took the dagger into custody and Brandon's cell phone when Brandon's Aunt Kathy delivered it to him. The phone was never searched for information or tested for blood. He didn't test the phone for blood. Let me say that again. He did not test the phone for blood. According to Grandfield's questionable expertise, it should have been free of any potential evidence after 2 weeks. But then, it was revealed that he had no problem sending off the dagger to be tested after being missing for almost 3 years. All right, next, Investigator Joel Gibson comes to the stand. As far as Hunt County's role in the investigation was concerned, he was the lead investigator on the case, and you've heard his voice several times already in previous episodes. The day ends just as he's sworn in, so it rolls over into day 3. All right, here we go, day 3. The State of Texas versus Brandon Dale Woodruff. Court Reporter, Volume 42. Day 3 begins by Katherine Ferguson attempting to remove a television interview with Brandon Woodruff from evidence that the prosecution entered without permission. Reading through the trial transcript, the prosecution attempts to do this very same thing several times over and over again. Katherine Ferguson objects to the point that it could loosely be turned into a horrific drinking game. If I had to take a shot every time the defense objected to the prosecution's ignorance, I'd be dead too. Let's avoid that, shall we? Again, the prosecution wants to edit anything in the video pertaining to Charla's psychiatric history. They marked documents with highlighted colors only to find out later that the judge is colorblind. Seriously, this was a thing. In fact, Judge Beacom tells the story about an attorney one time that took great lengths to color code everything in his case to explain it to the judge. And he just looked at him and said, "This all looks the same to me." You can't make this stuff up, ladies and gentlemen. So after a bit of back and forth, the judge said that he would review the video later and see what he would allow in. All right, bring in the jury. Investigator Gibson comes back to the stand and states that Investigator Brandon Bobbitt was the person holding the video camera during the, quote, lights out walkthrough of the murder scene. All right, we have a writer's note from C. Derek Miller. In the interest of full disclosure, Brandon Bobbitt is my cousin. The curse of growing up in a rural county. I'm not sure at this point if he's done anything wrong, but he'll get no sugarcoating from my words. Guaranteed. All right, so in one scene, Investigator Gibson claims that Investigator Bobbitt touched evidence while filming the video without wearing gloves. See? I told you I wouldn't let him slide. But don't worry, we haven't come to expect anything less from the Hunt County Sheriff's Department. All right, end writer's note. Thank you, C. Derek, for having the full disclosure at our fingertips. So Detective Gibson attended the autopsy with our befuddled hero, Ranger Collins. He was also the investigator to search the now infamous Dagger Barn, but decided not to search through every single box because it was just too cluttered. He also claimed that even though he was the lead investigator on the case, Jeffrey Collins was making all of the calls. He said that Collins was definitely the one who suggested filming the crime scene with the lights off. Personal note, t-shirts and bumper stickers that say Ranger Collins does it with the lights off are now available. Then he says that they never filmed it again with the lights on because the batteries died. His report claimed that Norma Woodruff had defensive wounds on her hands and a few stray hairs. The hairs were never tested. Ah, the hairs. Yes, the hairs. The infamous hairs. Well, I promised you in earlier episodes that eventually we'd talk about the stray hairs. And we'll get to those hairs first thing next week. You will not want to miss what happened with the stray hairs. It'll make you lose your faith in the forensic medical field. And that's, for me, hard to do. So until then, here's a little peek into next week's episode. Don't forget to stay aware, stay strong, and get involved. See you next week.
Okay, now you said that Brandon wasn't allowed to drive that truck except for going to a prom. Is that correct?
Yes.
Do you recall telling something different for the Rangers?
No.
If I showed you your statement, a transcript of your statement to the Rangers, do you think that might refresh your recollection some?
Yes.
The second interview, pages 39 and 40. Now, Miss Woodruff, I'm going to have to show you these pages, and I don't want you to read them out loud to the jury. I just want you to read them to yourself, okay?
Yes, ma'am.
All right. And if you would start here at about line 19 on page 39, and just read down there to yourself, please, ma'am.
Yes, ma'am.
Okay. Does that refresh your recollection, ma'am?
Yes, ma'am.
And you told the Rangers that you knew Brandon drove that you only drove the truck once, but that you knew Brandon drove it a lot more than you did. Isn't that correct?
Yes, ma'am.